Part 5 of Insolvency and Bankruptcy Code Amendment Act 2026. So we are discussing on resolution plan, the major amendments under Section 30 and Section 31. A detailed FAQ with answers. What are the major amendments made to a resolution plan and the provisions under IBC? The Insolvency and Bankruptcy Code Amendment Act 2026 introduces a significant reforms to Section 30 and Section 31, which governs the preparation, approval, and implementation of resolution plans. The objectives of these amendments are: it ensures a fair distribution among creditors and improve implementation of approved resolution plans, reduce litigations after approval, and protect government licenses and approvals, and provide certainty regarding extinguishment of past claims, and strengthen accountability of the Committee of Creditors. These amendments are expected to enhance the effectiveness of the corporate insolvency resolution process. So, what changes has been made regarding payment to dissenting financial creditors? This is one of the most important amendments to the insertion of this Section 30 subsection 2 clause BA. The resolution plan must now provide payment to financial creditors who do not vote in favor of the resolution plan. The amount payable shall not be less than the lower of the amount receivable by such creditor under liquidation in accordance with Section 53, or the amount that such creditor would have received if the resolution plan proceed had been distributed strictly according to the waterfall mechanism under Section 53. So the amendment also clarifies that such distribution shall be treated as a fair and equitable to dissenting financial creditors. Why was this amendment has been introduced? The answer is disputes frequently arose regarding payment to dissenting financial creditors. So several resolution plans were challenged before NCLT, NCLT, and Supreme Court on the ground that dissenting creditors had not received equitable treatment. So these amendments aim to protect the minority financial creditors and reduce litigation, provide certainty in distribution, maintain commercial wisdom of the Committee of Creditors, and balance the interest of all the stakeholders. So this statutory clarification is expected to bring greater consistency in resolution plan approvals. So what amendment has been made regarding implementation and supervision of the resolution plan? So the amendment Section 30 requires every resolution plan to provide for implementation and supervision through dedicated committee. The committee consists of resolution professional or any other insolvency professional, representative of one or more class of creditors, successful resolution applicant. So the importance, this committee will monitor implementation of the resolution plan, resolve practical issues, protect creditor interest, ensure compliance within timelines, and facilitate a smooth transition of the management. This institutional mechanism is expected to reduce post-approval disputes. So what additional responsibility has been imposed on the Committee of Creditors? The amendment now requires the Committee of Creditors to record reasons while approving a resolution plan under Section 30 subsection 4. Previously, the COC approved resolution plan by the prescribed voting percentage without statutory requirement to record reasons. Now, recording reason will improve transparency and demonstrate the application of mind, reduces the allegations, arbitrariness. So, facilitate the judicial review wherever necessary. So, however, the commercial wisdom of the COC continues to remain paramount. So, what is the concept of a two-stage approval introduced under Section 31? This amendment introduced an innovative, this is a two-stage approval mechanism under Section 31. Stage 1 is that approve implementation of the resolution plan. Stage 2 is approve the manner of the distribution among the stakeholders within 30 days. Within 30 days thereafter. So the benefits are faster implementation and early takeover by the successful resolution applicant and reduced delay caused by the distribution disputes. So the preservation of business value. This is a significant procedural reform. Can the adjudicating authority allow correctness of the defects in a resolution plan? Answer is yes. So the amendment section 31 provides that before rejecting the resolution plan, the adjudicating authority may issue a notice to the committee of creditors to rectify the defects. The practical significance here is the minor procedural deficiencies should not automatically result in rejection. So instead, the COC gets an opportunity to correct the drafting errors, provide additional information, and modify the procedural aspects if any. So this ensures compliance with the statutory requirements. So this reduces unnecessary rejection of the commercially viable resolution plans. So what timelines has been prescribed for approval of resolution plan? So this amendment requires the adjudicating authority to pass an order approving or rejecting the resolution plan within 30 days from the receipt of the plan. If the order cannot be passed within the period, then adjudicating authority must record the reasons for the delay. The reasons will be recorded. So this amendment improves judicial accountability, speed up CIRP, and increases investor confidence, and also prevents erosion of the asset value. So what protection has been provided for the government licenses and approvals? A new provision has been inserted under Section 31 to protect the licenses, permits, registrations, quotas, concessions, clearances, and similar rights associated with the corporate debtor. So the amendment provides that these rights shall not be suspended or terminated merely because a resolution plan has been approved, provided the corporate debtor or the successful resolution applicant complies with the applicable conditions for the remaining period. Here, this example includes mining of lease, or environmental clearances, or telecom licenses, or factory licenses, government approvals, even sectoral regulator permissions. So these provisions preserves the business continuity and enhances the value of the corporate debtor. What happens to claims after approval of the resolution plan? This amendment section 31 introduces an important clarification regarding the treatment of the pre-approval claims. Unless otherwise provided in the resolution plan, claims against the corporate debtor and its assets arising before approval of the resolution plan stand extinguished. No fresh proceedings can be initiated against the corporate debtor based on such claims. So the pending proceedings in relation to such claims cannot continue. So this provides certainty to the successful resolution applicant and promotes a genuine fresh start for the corporate debtor. Does the extinguishment of claims protect the promoters and guarantors? No. The amendment specifically clarifies that the extinguishment of claims against the corporate debtor does not affect claims or proceedings against the promoters. So this, whatever we are talking, this amendment specifically clarifies the extinguishment of claims against the corporate debtor does not affect claims or proceedings against promoters. persons in management control or personal guarantors or corporate guarantors or any personal jointly or severally liable with the corporate debtor. So thus, while the corporate debtor receives a clean slate, other liable persons continue to remain responsible under applicable law. So what happens if a guarantor pays the debt after approval of the resolution plan? The amendment further provides that where a person having a joint liability or joint or several liability pays the debt after approval of the resolution plan, such person cannot seek indemnification from the corporate debtor. This ensures that the corporate debtor truly receives a fresh start and is not burdened with the new reimbursement. So how will these amendments benefit stakeholders? See, for the financial creditors, fair treatment for dissenting creditors, better implementation of the resolution plans, reduced litigation, and even resolution applicants, protection of licenses and approvals, great advantage, certainty regarding extinguishment of the historical claims, faster implementation. Even for resolution professionals, better supervision framework, defined implementation, and a clear mechanism is there. Even for corporate debtors, faster revival and improved business continuity will be there. Fresh start after approval. So even for NCLT, it is a clear statutory timelines, reduced procedural disputes, better quality of resolution plans. So here the takeaway is that the amendment section 30 and section 31 represents one of the most significant reform under IBC. So the takeaways include the fair treatment of dissenting financial creditors and the mandatory recording the reasons by the COC, two-stage approval of the resolution plans, and 30-day timeline for approval, protection of government licenses and regulatory approvals, extinguishment of historical claims against the corporate debtor, continued liability of the promoters and guarantors, and improved implementation and supervision of the resolution plans. So these reforms strengthen the confidence of the insolvency regime and facilitate faster and more effective corporate restructuring. Thank you. We'll meet in part 6. We have 2 channels, RR Corporates, other channel RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss my latest videos.